Hello, in this video we are going to explore a landmark case in contract law. Please note this video is only for educational purposes. Carlill vs. Carbolic Smoke Ball Co, 1893. In the late 19th century, during the era of horse-drawn carriages, elegant top hats, and peculiar medical remedies, a company named the Carbolic Smoke Ball Co made a bold promise. They claimed to have a miraculous cure for influenza, a device called the Carbolic Smoke Ball. This strange little contraption was meant to protect people from colds and the deadly flu by inhaling carbolic acid vapors through their noses. But little did they know, their extravagant advertisement would land them in one of the most famous contract law cases in history. An AD was published in the newspaper stating, "To all flu sufferers, we guarantee that our Carbolic Smoke Ball will protect you from influenza, and if you do catch the flu while using it as directed, we will pay you £100. To show our sincerity, we have deposited £1,000 in the bank." It sounded too good to be true, but the company's ad was everywhere, and it certainly caught the attention of one woman, that was Mrs. Carlill. Mrs. Louisa Carlill, like many others, was worried about the flu. Seeing the ad, she thought, why not? She purchased the smoke ball, used it exactly as instructed, and trusted it would keep her safe. But fate had other plans. Despite using the product correctly, she still fell ill with influenza. Disappointed but determined, she remembered the company's promise. She wrote to Carbolic Smoke Ball Company, demanding her £100. But the company's response, not what she expected. A man at Carbolic Smoke Ball County reads the letter and chuckles. And says, "Ah, dear Mrs. Carlill, that advertisement. It wasn't a real contract, just a bit of clever marketing to sell more smoke balls. Surely, no reasonable person would take it seriously." But Mrs. Carlill wasn't about to be fooled. If they made a promise, she expected them to keep it. So, she took them to court. The court had to decide whether the company's advertisement is a legally binding contract or just an empty sales pitch. The judge looked seriously at Mrs. Carlill and the company's lawyer standing before the bench. In contract law, a valid agreement requires three things. 1. An offer, a clear promise made by one party. 2. Acceptance, the other party must agree to the offer. 3. Consideration, something of value must be exchanged. The company argued that their ad was not a serious offer, just a marketing trick to sell more smoke balls. But the court had a different view. They pointed out the advertisement was specific and clear about the reward. The company claimed to have deposited £1,000, showing serious intent. Mrs. Carlill followed the conditions exactly. She used the product as instructed. Since Mrs. Carlill performed her part of the contract, the company was legally bound to pay her the reward. The court ruled in favor of Mrs. Carlill. The company had made a unilateral offer to the public, and when Mrs. Carlill fulfilled the conditions, a contract was formed. This case became a landmark ruling in contract law, establishing that advertisements can be legally binding offers if they show clear intent. A unilateral contract is enforceable when someone completes the stated conditions. Mrs. Carlill smiles as she receives £100. The company looks defeated. The judge wrote the final ruling. Answer: a simple newspaper ad became the foundation for modern contract law. The next time you see a bold marketing claim, remember Mrs. Carlill's fight for justice.